Hi, my name is Rita Amber and I welcome you to hashtag IP series and Happy New Year. Welcome to 2021. So if you follow me on Twitter, you must have seen my post on trend for 2021, which I did in collaboration with Garnet Law and Tech Hive Advisory. And one of the things that was mentioned or that we talked about was social media call out. I mean, over the last 3 years, we've seen more social media call out in relation to intellectual property theft, whether or not they're through. So if you're just listening to IP series for the first time, what we do here basically is talk about recent intellectual property cases and development globally. This could take the form of copyright, trademark, patent, industrial design, trade secrets, plant variety, geographical indication, and biotech. Please favorite my podcast on Anchor, and you can listen to IP series on Spotify, Apple and Google Podcasts, Breaker, Radio Public, Listen Notes, and Overcast. Now, today's case study, it really broke my heart reading it on Twitter because for me, I felt the person tweeting was rather ignorant about the very basic things of intellectual property, which is consent, permission, and authorization is very, very, very important. Okay, guys, let's just get right into it, and I hope someone understands this from my own point of view. This is my own point of view anyway. And as far as I'm concerned, the fact that an IP owner did not give you the CPA, you remember, consent, permission, authorization, does not give you the right to go ahead and produce or make, sell, or distribute that person's creation or innovation. So yeah, welcome, and let me just give you guys a gist about the case. So welcome to today's IP series, where I'll be talking about I won it, I got it, not in IP. And this is with regards to a design dispute that crossed my timeline on the 9th of January. So I saw a post by a Twitter handle at I am Emmanuel with a danfo inspired bag, and it read, "Ladies, what comes to your mind when you see this bag? If worked on, will you buy? If yes, how much will you be willing to pay for this?" And then hashtag Zara feminism, hashtag Trump. And then I saw a response to that. Really? Stealing someone else's hard work? Really? With a question mark and exclamation. And I was like, the conversations just kept going on and going on. A lot of people were like, he stole it, he didn't steal it. And I was like, okay, I need to put a stop to all of this and settle this now. So here's a brief summary about the case. Now, at I am Emmanuel, had sometime in May 2020 said a friend had sent him the design via WhatsApp. That is the design of the danfo inspired bag, and he took it upon himself to find the real IP owner and designer, and he found out on Instagram. Like, bravo! That was like, the first thing you have to do when you're doing your IP due diligence is to verify who the author of the creation is. So yeah, kudos to him for that. Then parties will now move their conversations from Instagram to WhatsApp. That means things were getting serious. He had said to that so the message he sent to her read, "Good morning from here. I saw your CC Echo designed bag on a friend's WhatsApp story, and I must say it's quite creative. I'm a businessman with strong ties with China. I sent the picture to one of my suppliers and they can get it to a real bag, which I think will do well in terms of sale. I mean, sending picture to the suppliers when you've not gotten permission, that's a no-no. But let's move on. I want to know if you're open for this so we can discuss the terms, then I can proceed. And Viera Amber responds and says, "Hi, good morning. Thank you so much for the kind words. The offer sounds amazing and promising. Thank you. I think we should discuss the terms first. Yes, I think we can proceed." And then we go to WhatsApp and he's like, "Hi, this is Faith. Vera Amber, this is your cool bag." And I say, "Great, how are you today?" She responds, "Fine, thank you. So since you designed the bag, I feel it's the right thing to do to involve you in the plan as I get the possibility from your creativity." I mean, oh well, let's go on. Then Faith says, "Okay." Now he says, "I have two proposals for you. I want to know if you'll be willing to sell the right to me to go ahead, produce the bag." Okay, I mean, I don't know how I feel about that proposal, but it's a no from me. You don't just walk up to a creative person and say, "I want you to sell so I can go ahead and produce." Anyways, the second one reads, I give you 1% of the every bag sold for the first 200 bags. So let's say the bag was sold for 10,000 naira. So that means Vera Amber, the creator of the bag, gets 1,000 naira. That's 1% now. No. So 10% would be 1,000 naira. So 1% is 100 naira. The nerve, man. And she says, "Are these the only proposal you have?" He said, "Yes, but open to hear your options." And Vera says, "Vera Amber owns all right to her design and they unfortunately can't be for sale." Very good, girl. So now, let's move on. Parties have, still having their conversation. So I'm going to give like a brief history about the bag. Brief history of the bag. So, um, a challenge called the hashtag FH challenge was organized by a handle called Femi Handbags on Instagram, and this post was made on the 24th of April. And like every other challenge, it had their rules, which reads as follows: you have to have followed at Femi Handbags. You have to imagine the bags of your dreams, sketch, draw, design an all leather bag using any design tools of your choice. Now you get to upload the design on your page and tag at Femi Handbag, and also use the hashtag design my our FH and hashtag the FH challenge. The design must be original. Terms and conditions apply. And then the winning prizes, the two designs with the most like and engagement will get made when we open our factory doors. PS, the members of the FH teams are not allowed to are not allowed to participate. Wink. And then on the 10th of May 2020, Vera Amber was announced as the winner of the bag with another designer called Flo Venus. Vera Amber's bag was said to be the most original and innovative designs, and these terminologies are very common in IPs, such as patent and design, where your creation or innovation has to be new and original. Now according to the designer, that's Vera. Now she says she got her inspiration. Vera says she got her inspiration from the repetitive elements of Lagos traffic. Oof, she stayed in Lagos traffic. So there was this traffic I spent 3 hours, 30 minutes. You know why I remember? It's because I was sweating from my head down to my toes. And the previous day I was already saying, "Oh, I'm going to move to Lagos. I'm going to move to Lagos." And then that That happened, and I was like, nah, 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 nah. Lagos can be crazy. Sometimes you miss your meetings, or you get late to your meetings. You're shuffling island, mainland, all those Lagos things. So then she goes further to release the Echo bag collection, which she made an Instagram post on the 9th of July 2020. Now, when dealing with intellectual property, documentation goes a long way to help you, especially when a dispute arises. At least we can now trace the history of the creation of your work or your innovation. It also helps your lawyers and the stakeholders and every other person that may be interested in knowing the history of how your creation came about. So imagine if she did not document all of these things. That's how Emmanuel have gone ahead to say that he owned the design of the CC Echo. But yeah, anyways, back to the stories. Party got talking. Emmanuel made the two offers to buy her rights as the IP rights. I presume IP rights are not cheap; they're rather expensive. And I saw a post recently where Boohoo was buying them Behams for how much was it again? Is it 50? But for a lot of money, you get. Um, so he needed her rights so she can allow him to produce the bag. I mean, that's not a good offer. As far as I'm concerned, it's a very bad offer. And I would not advise any creative person just starting out to sell whatever creation they've made. I'd rather they license it and generate income from it. Either you go into an exclusive license or a non-exclusive license. So I think the options there would have been going to a non-exclusive license agreements with Emmanuel to produce the bag for XYZ amount, and you're entitled to a certain commission of the profit he makes from selling all the bags, not 200 pieces. Like, come on, man. Okay, let's move on. If not, I'm upset. Yeah, and then the second option was he would give her 1% for the first 200 bags. No, now her response was she owns all the rights to her designs and her designs were not for sale. Now the conversation gets interesting. Um, and for me, I kind of felt like when I read his post, he made it seem like he was doing her a favor by offering her to give her 1% of the first 200 sales and also reproducing the bags, and she was rejecting him, you know. Now, according to him, he went ahead to discuss with his lawyer. So this is what his post said. The offer in this case wasn't okay with her, that's Viera Amber, and she wasn't ready to give an offer. Thus, she declined and we both moved on. And I asked my lawyer what could be done, and he advised if I see a business opportunity in it, I can proceed with my talks with my manufacturers in general. First of all, that lawyer, I don't know if he's an IP lawyer, but I don't want to call him a fraud, but he badly advised Emmanuel. I mean, you can't tell Emmanuel to go ahead to reproduce someone else's work, even when the person has told you, like, so I want this thing, I must have it. That's not how it works in IP, which is why I titled it, I want it, I got it, not in IP. If you love Ariana Grande, just like me, I'm sure you've listened to Seven Rings, and thank you. Next. Okay, I think I'm digressing right now. But yeah, I mean, Faith even went ahead to, do like a longer post explaining and telling him that. So this is Faith says, Faith, Viera Amber appreciates your proposal thus far. She's a highly motivated, visionary brand, and this has and will only be achieved by making smart business decisions. And I agree. Every creative person and innovative person has to make smart business decisions. You're here to make money, not to. Anyways, now she says, I think you can still take your time to make your estimates. Then you can email us an e-copy so it can be reviewed. If they are still feasible, of course, we can move on from there if the item is still available for proposal. Remember, she already won that competition, and the company Femi Handbag had said they were going to reproduce or produce the bag for her once they commence manufacturing. And she says, unfortunately, proposal within 1% amounts to zero or no profit. And it's true for the brand, and proposals within 200 says also eventually means selling the rights of the bag, neither of which is favorable to Viera Amber. Smart business woman. Once again, I appreciate your proposal. If you have any other suggestions, we will be glad to hear it. Thank you very much. And then Emmanuel goes to say, sure, I understand, no problem. Thanks for your time. And this is where he went ahead to talk to his lawyer. I mean, someone has told you her condition, but for you, it wasn't good enough. I mean, I guess it's like it's supposed to be like a negotiation, sort of. I negotiate, you counter, and all that. And but he's saying here he discussed with his lawyer who encouraged him to take an opportunity. I mean, how would you call that an opportunity? You started well by identifying the IP owner, the designer of the bag. You now took a second step by making an offer, which wasn't good enough for the designer. I mean, come on, who would take such offer? It's very poor. Now, he will now go further to reproduce that bag in a similar shade. And I got a question from someone asking me, what if he had done it in a different shade? So if you put the bags side by side, and I can see the similarities, and I can say, oh, this bag looks like Viera's bag. Isn't that copying or IP theft? So he reproduces a replica of the bag without Viera Amber's consent, permission, or authorization. It's bad and disrespectful. And the CPA is like one of the most fundamental things about IP, whether it has to do with a creative work or an innovative work. Now, on Twitter, I had asked the question, can I reproduce another person's creation or innovation after they have said no and refused your proposal by altering certain aspects? And majority, like 98.3% said no, while 0% said yes, and then 1.7% said na business opportunity. I think these people were just trying to be naughty. But you can see that. I mean, I don't need to put it and say, this is IP tech, but if I put it in a clear layman and I say, can I reproduce another person's creation or innovation? I mean, he even went as far as saying, after all, you people use take a Buka's design to go and give to your tailor. I mean, so there's something about IP that people fail to understand. If I do something for my own private use, I'm going to criticize it, or for educational purpose, research, news reporting, and I'm not making money from those things. But wherever I do it because I want to make money, that's where the issue of IP theft comes into place. The use, what was the amount that was used? Now, I gave an example talking about the Ariana Grande and Forever 21 case, where in December 2018, Forever 21 had approached her stating that they wanted to use her name and likeness. But she rejected it because the offer, according to her, was not good enough for an artist like her. I mean, check out now. And then they went ahead to publish 30 unauthorized pictures and videos using her name to promote their clothing and building products. They even went as far as using a model that had a resemblance to her. Like, how, imagine how far they went just to deceive the public. And so I did share some pictures about the works of Forever 21. However, Ariana Grande sued Forever 21 for $10 million in damages. The last time I read about the case, they said Forever 21 had filed for bankruptcy, which kind of put the suit to a stop. And that's story for another day. But then I also have another series which is coming over. I'll be talking about serial infringers, and let me just stop there. Okay, so Emmanuel now goes further to state a well-known IP principle, which is that ideas cannot be copied. He said, but I ensure it's not exactly the same design. Really, dude, yours is like butter yellow, hers is like mustard yellow. And so I decided to proceed, and we try different options. The original design, the prototype isn't exactly the same. Ideas can be copied or modeled after. Some of you see Ebukat's shirt, give your tailor and sue, same, don't you? I mean, we give to our tailors to sew for us, not to go and do mass production and go and sell to other people. Anyways, in IP doesn't protect an idea. We have to see like a creative work or an innovative work in order for it to enjoy legal backing. So the question that a lot of people were asking or people were talking about is the bag in question. Is it just a mere idea or it's a work that enjoys IP protection? And I said it's a work that enjoys a multi-layered IP protection, which could be in the form of the copyright and design right, though unregistered, because the Echo CC bag was a sketch work not yet produced. So I mean it's already in a fixed form. A sketch is a fixed form, a fixed medium. And copyright, as we know, protects original literary and artistic work expressed in a fixed medium. It could be a sketch work like the CC Echo bag, a book, film, music, all those things under section 1, sub 1 and paragraph 2 of our Nigerian copyright. And then subsection 3 says that that an artistic work shall not be eligible for protection if at the time the work was made was not intended to be used as a model or pattern to be multiplied by any industrial process by the author. I mean, it's only Vera that can answer this particular question, because basically what this subsection is saying is that if the author who creates the work, did not have any intention to use, let's say, the sketch now, to be multiplied, so like mass produced by any industrial process, it's only that work cannot enjoy protection, is not eligible for copyright protection. Now, Vera, you're the only one that can answer this question. Was that your intention to multiply your bag using industrial process? Please tell us. And then section 6 sub paragraph B talks about the right that an artist can enjoy, which includes reproducing the work in any material form, publish the work, which Vera did on her Instagram page, include the work in any cinematograph film. She also did a short video showcasing how the bags were created, etc., etc. And then on the principle of ownership and authorship, section 10 sub 1 provides that ownership shall vest initially in the author of a work, and then author in copyright is the person who created the work, while ownership is when a person merely contributes information or suggestion, but not how the work is expressed at the end of the day, because it's the person that expresses the work, just like how Vera did. She expressed her CC Echo, the danfo inspired bag into a CC Echo, mustard yellow bag. And then I went further to ask, who do you think owns the bag? And 87.3% said Vera owns the bag, while 3.6% voted in saying Olorunshola Emmanuel owned the bag, and then 9.1 said they were confused as to who owned the bag or not. And then I asked the question, who is the author of the yellow danfo bus bag? And 90.9% said Viera Amber, and then 5.5 said Olorunshola Emmanuel. So I'm laughing because I'd put the option of "Whoa, leave me," and 3.6% voted for that. Unfortunately for this one, no one said they were confused. So yeah, furthermore, the fact that the parties had no form of contract, I mean, there was no contract between Vera and Emmanuel, and the work wasn't done while Vera was employed by Emmanuel, so he can't come and claim to be the author. Remember, I had said that the author is the person who creates the work, while the owner is the person who made some contribution but did not express the work at the end of the day. And Emmanuel did neither of that. There's a thin line between imitation and copying, and it's pretty obvious that Emmanuel's work is an imitation or a copy of Viera Amber's yellow bus bag. Now, 58.8% said Emmanuel's work was an imitation or a copy of Viera Amber's yellow danfo bus bag, while 39.2 said that it was an imitation. So I'm laughing at him because 2% voted and said free the guy. I go free the guy when you go copy another person work. Anyway, so remember Emmanuel had asked Farah to sell her right to him, and so he can go ahead to reproduce her back. Now, in section 11 sub 1, now according to section 11 sub 1 of the Nigerian Copyright Act, it states that copyright can be transmitted in the following ways: by assignment, or by testamentary disposition, or by operation of law. And we know that IP is an intangible asset and not a tangible asset. Um, it can be transmitted as stated as both. And since Vera refused to transfer her rights, she still owns and maintains all the rights in her design. When using IP that doesn't belong to you, it's best to acquire or buy the rights to use by getting a license, which Emmanuel failed to opt for. A whole businessman. Anyways, for creators and innovators, IP protection is an investment which enhances the market value of their work. Now, even if it's for a limited period of time, which for literary, musical, and artistic work um, is for the lifetime of the author plus 70 years after the end of the year in which the author dies. And then when it comes to who can claim authorship, section 12 sub 2 states that the right in question can be perpetual, inalienable, and imperceptible. An author can enjoy economic right to commercialize and exploit their work. They also enjoy moral right, also known as paternity right, to have a say as to how their works is being used. The main bone of contention here is whether the actions of Emmanuel can be considered to be an IP infringement or theft. And I did a poll again, and 63.6% voted and said that Emmanuel's action can be considered to be an infringement, while 15.2 said it wasn't an infringement, while 21.2 said they were not sure. And so, yeah, going forward, section 15 paragraph 6 states that any act done by the person who, without the license or authorization of the author, does or cause any other person to do any act controlled by copyright artists to reproduce, to sell, distribute, etc., or import into Nigeria other than for his private or domestic use can be termed to be an infringement. So basically, Emmanuel had, informed his manufacturers in China, and they had, created manufactured the bag, and he imported it into Nigeria. I was thinking of selling. So he wasn't doing it for his private use or domestic. He had the intention of selling it to make profit from it, and it's only the author of the work that can actually benefit from that. Another is if he distributes by way of trade, offer for sale or hire, or any purpose prejudicial to the owner of the copyright, any article in respect of which the copyright is infringed upon in paragraph. So I then asked again, did Emmanuel infringe in Vera's design? And 92.9 wow said he did, while 7.1 refused to say anything. Really, guys? Anyways, according to section 16, in order for you to sue for copyright infringement, you have to do that at the Federal High Court, which has the jurisdiction to hear IP related disputes. This can be done by the owner of the work, the person who the right was assigned to in an exclusive license which Emmanuel doesn't even have. Why subsection 3 provides that where an infringement occurs, and at the time it did, the defendant is now aware that the work enjoys copyright protection, the plaintiff shall be entitled to an account of profit and not damages. So basically, if the defendant is claiming that, he didn't know that your work is eligible for copyright protection, blah 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 blah, then you cannot sue the person for damages. You can only sue the person for profit. So if Vera wants to go to court now, she's going to sue him for account of profits. how much have you made from selling these bags? You get. So I now went further to ask, do you honestly think that Emmanuel doesn't know that Vera sketches enjoy automatic IP protection? 81% said no, I don't. And I agree with them. I don't think he knew that. He just assumed, oh, the sketch was an idea, which is why he kept referring to it as an idea. IP doesn't protect an idea. Sorry. Okay, while 14.3% said they thought that he knew the sketch was copyrighted, while 4.8, I think my poll questions, my options are always really funny, and then 4.8% said wait and save. Sorry, Mabino, I apologize. So on the second multi-layered IP protection, I talked about design, industrial design or design rights. Now, according to Section 12 of the Patent and Design Act, um, a design is said to be any combination of lines or colors, or both lines and colors, or any three-dimensional form, whether or not associated with colors, is an industrial design. If it was intended by the designer to be used as a model or patent to be multiplied by industrial process, and it's not intended to solely obtain a technical, I mean, too much technicalities right now, but Section 13 says the criteria or requirement to qualify as a design is that it must be registrable as a design, it must be new, not contrary to public order or morality. However, Subsection 3 provides that any disclosure to the public anywhere at any time by means of description is not new. Now, Emmanuel should pay close attention to subsection 5, specifically the keywords, which says, I quote, minor or essential ways from an earlier design, which is basically what he did. He just, tweaked the Viera Amber's danfo inspired bag and started saying, oh, my own design is new, has just a prototype. Okay. Now, who has the right to register a design in Nigeria? Section 14 sub 2 says the statutory creator, who may not be the true creator. And then we in Nigeria we apply the first to file principle. So it's the first person to file that gets to be called the that gets to enjoy the legal backing, and then if you can claim foreign priority, whereby you registered internationally, you want to come register in Nigeria, there's a way it can be calculated. And the question is, did any of these parties file or register this intellectual property? I mean, I don't really know, and I don't think so. So it's more like it's an unregistered design. So I then asked, who can apply for the design rights in the danfo bag? And 91.3% voted for Vera. 0% did not vote for Emmanuel. Smart. And then 8.7% said next. Come on, guys, please. Now, when a creator or innovator registers their design, Section 29 grants them the following right: that they only have the right to reproduce the design in the manufacture of a product, import it, sell it, or utilize it for commercial purposes. A product reproducing the design or holding such a product to sell it or utilize it for commercial purposes. However, Subsection 2 provides that the reproduction of a registered industrial design is not lawful for the purposes of Subsection 1, which talks about it differs in minor or inessential ways from the design, because it concerns a type of product other than the type which the design is concerned. So one important reason for registering your design is that you're able to prevent a third party or any other person from copying or imitating your work. You also strengthen your competitive position within that particular jurisdiction. And in Nigeria, an unregistered design enjoys a limited protection. I'll take that again. In Nigeria, Unregistered design enjoys a limited protection as it is difficult to enforce, unlike a registered design. So once a product is manufactured or created, the designer has up to 12 months, 1 and 2, 12 months to register it. A registered design lasts for 5 years, but may be extended for 2 further periods each of 5 years. And in Nigeria, the law allows for a grace period of 6 months from the moment a design was made public. So, public or disclosed or published, like in Viera's case, for an instance where articles bearing the design are sold, displayed at a trade show, officially recognized exhibition, blah blah blah. Sorry, brochure or advertisement prior to filing an application. During that period, you may market your design without losing its novelty, and you may still apply to register the design. Viera Amber, in this case, her design was created in May. That means she has up until April 2021 to register her design if she has not registered registering it. So what happens when a designer doesn't want the design again? So under the law, it says the designer can renounce the registration by writing a letter, a written declaration to the registrar, as stated in section 21, sub 1, 2, and by listing the kind of work that can be renounced. And we don't see any scenario where Viera renounced her design that Emmanuel will come and start saying he created a new design. Section 34 talks about assignment and transfer, joint ownership, which is not the case here, as Viera never assigned, she never transferred, and neither she and Emmanuel were co-designers in the competition. So I'll give an example of a creative person that registered her design. So in 2019, Diola Sage registered Komole Candice Ashoke. I mean, everyone is talking about Diola Sage's Ashoke, Washwebi, brides are wearing. I mean, she's just everywhere. So she went as far as registering her this Komole Candid, uh, and she put an IP notice saying violation will lead to the person being prosecuted. And I was really, really impressed because, you get to see more creative persons being aware of the rights they own. And then Section 25 provides that any infringement with regards to a design, the designer shall get the following relief by way of damages, injunction, accounts, or otherwise shall be the plaintiff as is available. When it came to copyright, he said if the defendant claimed not to know that the work was eligible for copyright protection, the plaintiff can only get account of profit. In design here, you get everything. You get an injunction, you get damages, you also get account for profit or any other thing that may be available to the plaintiff at the end of the day. And then you also get to sue at the Federal High Court, which has a jurisdiction to hear all intellectual property related dispute. Now, under Rules 22, paragraph C of the design rules, it lists the design that are excluded from registration, which includes printed matter primarily of a literary or artistic character, including book jackets, advertisements, certificates, trade form, leaflets, etc. So you see, this is one of the reasons why you need to contact your IP lawyer when you're doing stuff. So you start your design, you just put the person on the note so the person can advise you properly. Now, this might be a sketch or a design. If you've seen the danfo banner, the question is it a new or original design? I mean, it's a bus, a regular bus out there, but the bag itself, um, does it involve novelty either in the pattern, the shape, or the way in which the old pattern or shape or ornament was applied to be special, to have some special. These are the things that needs to be confirmed. And according to the challenge which Viera won, Her design was said to be original. I mean, have you ever seen a danfo inspired handbag? Appearance is key when it comes to industrial design. Um, which is why when you're opting for a multi-layered protection, always understand the difference between the forms of IP. So you need to know the difference between copyright, trademark, patent, industrial design, trade secret, don't variety, all of those things. And then maximize them. Design right. When it comes, so if you're comparing copyright design for a bag, which one is stronger? You always, so it's advisable that you go for design right because it's considered to be stronger. So in conclusion, um, my recommendation from this case is always do your investigation to determine the chain of title and also get IP clearance, which Emmanuel started well but took the wrong turn on advice. Consent, permission, and authorization is very important. If you don't get it, please don't continue with whatever it is you want to do with that creative work. When it comes to design, take note of the keyword differs in minor or inessential way, does not qualify or make your design new. Um, if you see a good business opportunity, make a good offer, not a 1% of first 200 offer, or sell me your right, let me go and reproduce. Let me go and reproduce. I don't know why I'm laughing. Apologies, guys. Um, Opt for partnerships, go into a partnership. That way you're getting fans from both the person's side and also you're combining everything. Or at best, get a license. Now, as a designer, a multi-layered protection is the best form of IP for your work. So one product can have like a copyright, a trademark, a design, a patent. So let's use Coca-Cola. Coca-Cola, the name is trademark. The shape of the bottle registered as a design. The content, the recipe for Coca-Cola, trade secret. Omo, have you seen their commercials? People don't know what people are missing in this Nigeria when it comes to IP. And I think one designer that really I enjoy watching their creation is the Dior Saddle bag. I mean, the day I watched it from when they did the sketch, just like Vera started with the sketch, and then the sketch to when the bags, everything was put together and made. It was really it was so beautiful to watch. I put up a link in when I made that post. It said, so if you want to Google it, it's called Inside the Making of the Timeless Dior Saddle Bag. I know there are a lot of counterfeits going out there being sold, but yeah. Then IP is everywhere. IP interfaces with everything. Every sector is an IP aspect to every sector. You need to commercialize, explore, and exploit your creation and inventions. Retain an IP lawyer. I don't know how many times I've said this for most of my series, but you really need an IP lawyer in your team. Learn, study, and understand the business aspect of your IP as it relates to your industry. So if you're a designer, what is the business aspect of IP when it comes to designing? You're thinking fashion, you're talking contracts, labor, a lot of things to consider. Also, in the event of a dispute or infringement, speak to your IP lawyer first. He's going to advise you on what to do. He's not going to tell you there's an opportunity, take it. No, 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 no. He's going to tell you whether or not you should, opt for partnership or licensing, help you with in determining title, chain of title, all those things. So in the event of a dispute, you also have two options. You can litigate or you can settle out of court by exploring alternative dispute resolution mechanism, such as mediation, arbitration, negotiation, or a hybrid mechanism whereby you can mediate then arbitrate or mediate and negotiate. And then finally, very important, document your creations and innovations. In this 2021, with 2020, everything that happened in 2020, everyone was locked. There was a lockdown. You need to start learning how to document and switch the position. We are switching the position. You get? Okay, so everything about this tweet was just it had like a tiny bit of Aria Grande in it. So positions, if you listen to position, please, this. That's what I'm talking about. So you need to switch things up as a creative person. we need to do things the right way. So yeah, if you learned something from this episode, please let me know. If you have questions, send me an email, ipseriesInfo@gmail.com. So until the next IP series, to have a lovely day, guys. Bye.